Francis.
Grace Omole, my lord. I want to announce my appearance for the claimant. G.A. Omole, my lord. Grace Omole, my lord. I want to announce my appearance for the claimant.
Okay. I got that.
For the claimant, my lord.
Yes, I got that. Who else is online?
Maybe it's Honorable Court. Yejide Ogunhitom for the defendants, my lord.
Okay, good. Okay, so this is the judgment for between Matthias Abada, claimant, and GIG Group Limited, the defendant. The claimant commenced this suit by general form of complaint, statement of fact, witness statement on oath, and other originating processes filed pursuant to the order of court dated 1st of March 2023. The claimant amended the statement on oath together with other originating processes and filed same on the 11th of April 2023, seeking the following reliefs. 1. A declaration of this court that the claimant is still in the employment of the defendant, having not resigned from his employment. Neither was his employment terminated by the defendant. And consequently, the defendant is in arrears in the payment of the claimant's salaries from December 2016, when he was asked to step aside till date, including any severance benefits as contained in the letter of offer of employment. 2, the payment of the sum of 13,200,000 naira only as unpaid salary for January 2017 to June 2022 as contained in the employment letter dated 2nd of April 2014. And order directing the defendant to pay to the claimant the sum of 3,168,000 naira only, which represents in-house weekly allowance in line with the company policy practice and in-house memo dated 9th of December 2014. 4, an order directing the defendant to pay to the claimant the sum of 2,040,000 naira only, which represents the claimant's annual leave benefit. An order directing the defendant to pay to the claimant the sum of 3,542,400 naira only, which represents 18% of the employee's monthly emolument, 10% contributed by the claimant of 9 years pension forfeited as contained in the letter of employment. 6, an order directing the defendant to pay to the claimant the sum of 2 million month end of year productivity allowance, which was never paid from 2014 when he was employed to 2022 as contained in the contract of employment. 7, general damages in the sum of 10 million naira only against the defendants for the delay, suffering, and financial hardship visited on the claimant by the defendant for the forced suspension and lack of salary from the defendant from December 2016 till date. 8, the payment of the sum of 5 million naira as cost of this action and for such further or other orders as this honorable court may deem fit to make in the circumstance. The claimant's case. By an employment letter dated 2nd April 2014, Exhibit C1, the claimant worked for over 10 years as Group Internal Audit Manager and promoted to Head of Audit. On the 8th of December 2016, without any query, he was instructed to attend end-of-year annual general meeting, AGM, where he was called out by the chairman/CEO of the defendant company and asked to step aside. His case is that he went to the office the very next day but was denied access and he was shut off from his company's software application. He did not get any response to his email sent to the chairman, CEO, or HR after the AGM, nor granted access into the company. His employment was not terminated as he was not given any letter of termination. He was not dismissed either. He was not dismissed, neither did he resign his appointment. He was not paid any entitlement despite several appeals to the chairman/CEO, culminating in the institution of this action against the defendant for the payment of all his entitlement. Trial in this suit commenced on the 26th of June 2024. The claimant testified as the sole witness and tendered 12 exhibits marked as Exhibit C1 to Exhibit C12. The offer of employment was marked as Exhibit C1, internal memo clarification outstanding allowance marked as Exhibit C2, internal memo interim chairman's brief marked as Exhibit C3, internal memo group audit activity report marked as Exhibit C4, internal memo email dated 29 March 2017 marked as Exhibit C5, email from claimant to the chairman CEO dated 14th March 2022 marked as Exhibit C6, claimant's email to the chairman dated 21st of April 2015, copy of ID card marked as Exhibit C8, copy of work review and restructure plan marked as Exhibit C9, copy of statement of account showing the salary payments marked as Exhibit C10, claimant's pension account statement marked as Exhibit C11, certificate of authentication marked as Exhibit C12. The defendant's case is that the defendant admits that the claimant was head group, that he was not diligent and committed, but was paid his basic salary, other benefits, and his pension was remitted. However, payment of bonuses was at the discretion of the defendant upon satisfactory performance of his employee. That on the 5th of December 2016, the claimant was instructed to attend the AGM at the head office slated for the 8th of December 2016, and that at the AGM, staff who performed well were commended and appreciated, while staff who underperformed were called out and encouraged. That after the AGM, the claimant failed to show up despite several opportunities given to him to return and expose the defendant to financial risk. The defendant was left with no option than to terminate him by paying 263,636 naira as 1 month's salary in lieu of notice. That all those who were asked to step aside, none was recalled to work, neither were they paid their entitlement. The defendant, having terminated the appointment by paying 1 month's salary in lieu, he was under no obligation to respond to his emails. That the payment of 13 months salary, gratuity, and bonuses was at the discretion of the was also remitted. For the defendant, Joel Iyamu, the human resource manager of the defendant, testified as DW1 via the witness statement on oath dated 19th October 2022, adopted on the 26th of June 2024. Mr. Iyamu also tendered one document, the claimant's letter of employment dated 2nd of April 2014 and admitted as Exhibit D1. In the body of the judgment, we have the defendant's final written address and also the claimant's written address. I'll go straight to the judgment of the court. The court's decision. During trial, the defense counsel had informed the court of his intention to object to some of the documents tendered by the claimant as exhibits at the final address stage. The court has noted that no objection was raised and will deem that intention as abandoned. The case before this court is whether the claimant is entitled to the relief sought. The relief shall be dealt with seriatim. The first relief is a declaration that the claimant is still in the employment of the defendant, having not resigned from his employment. Neither was his employment terminated by the defendant, and consequently, the defendant is in arrears in the payment of the claimant's salaries from December 2016, when he was asked to step aside till date, including any severance benefits as contained in the letter of offer of employment. Parties are in agreement that Matthias Abada was instructed to attend an AGM at the head office of his employer on Thursday, the 8th of December 2016. And in the course of the meeting, the chairman CEO called out names of some staff to step aside, and claimant was one of them. In paragraph 15 of his statement of fact and witness statement on oath, same day he made calls to the office the next day, but was not granted access into the organization. And he made several attempts to speak to the HR manager and the CEO, but to no avail. The defendant in paragraph 10 and 11 of his statement of defense stated that after the AGM of 8 December, claimant failed to show up at work without approval and without reasons for his absence. This action breached the terms of his employment. The defendant in paragraph 13 and 15 of the statement of defense stated that despite several opportunities given to him to return, which he failed to utilize, after about 2 months, the defendant terminated the claimant's employment by paying him 1 month's salary in lieu of notice in line with the terms of the offer of employment in Exhibit C1/D1. The claimant is therefore seeking for a declaration that he has not resigned from employment and his employment has not been terminated. Indeed, by the facts and evidence before the court, the claimant did not tender his resignation from employment. The defendant's case is that the claimant abandoned his work for 2 months. 2 months. The defendant terminated the claimant's employment by paying 1 month's salary in lieu of notice. Following the sequence of events that followed the instruction to step aside, the claimant, in proof of his employment and the conditions of service, tendered Exhibit C1, which is the letter of employment dated 2nd of April 2014, which had certain conditions contained therein. Paragraph 12 has embedded, and I quote, "Other conditions of service are as contained in the company's employee handbook," end of quotation. It is important to state at this point that the claimant did not tender the company's employee handbook. This court shall therefore restrict itself to the offer letter Exhibit C1. Paragraph 10 deals with a termination, and it reads, and I quote, "Upon confirmation, either party can terminate the appointment by also giving a notice of 1 month or payment of 1 month salary in lieu of notice," end of quotation. As stated earlier, the claimant was asked to step aside on the 8th of December. And due to his absence at work, the defendant, after about 2 months, paid 1 month salary in lieu of notice. The task before this court is to determine whether by the conduct of the claimant, he has not breached the contract of employment by abandoning his work to entitle the defendant to terminate and pay 1 month salary in lieu of notice. In paragraph 15 of the claimant's witness statement on oath, he testified that after the step aside instruction at the EGM, he made unsuccessful attempts to reach HRM and the CEO. The defendant in paragraph 10 of his statement of defense and in his final written address vehemently denied this and maintained that the claimant absconded and abandoned his duty post, that he was never denied access to the office the day after the AGM. Therefore, he breached a fundamental term of the contract. Learned Defense Counsel drew the attention of the court to the fact that no shred of evidence was tendered by the claimant in proof of these allegations. The defendant could not have waited indefinitely. His disappearance from work was without cause and no notice of his whereabouts was availed the defendant. Therefore, claimant's absence from work being an aberration, a flagrant breach of his contract of employment, the employer had no choice but to proceed to pay the defendant's salary in lieu of notice, to pay the claimant's salary in lieu of notice in accordance with the employment contract. The court is also mindful of the claimant's reporter in the reply to the statement of fact that besides the fact that he was denied access to the office the next day and his calls and texts were not responded to, the claimant in paragraph 6 of his reply to the statement of defense averred that the day after the instruction to step aside, his company application software used to manage and execute his work was disabled and he was denied access. This was not controverted nor challenged under cross-examination during trial. The implication of logging out his staff from the company's software application would amount to refusal to provide work for his staff and an outright termination of the employment. It is claimant's testimony that he was denied access into the workplace. The question whether the claimant was ever communicated to be at the work premises was also raised at trial. And DW1 testified that he had no document to show he ever called the claimant or asked why he did not come to work. Neither did DW1 issue him a termination letter. On the issue of abandonment of his duty, the claimant, in a bid to narrate the sequence of events after the AGM meeting of 8th of December, and to establish that the instruction to step aside was orchestrated against him alone to deny him access of the premises, stated in paragraph 21 and 27 of his witness statement on oath that almost everyone except him was recalled back to the company, and some of the senior managers were also paid their entitlement. The defendant in paragraph 18 and 22 of his statement of defense denied this as, and I quote, nothing but a concocted lie, or at best, a thing which exists only in the claimant's imagination, end of quotation. The defendant, however, contradicted himself during cross-examination when counsel to the claimant asked defense counsel, so what basis have you to say he did not come to work? DW1 answered, the step-aside order was a verbal order, not directed only to the claimant, but to other people who underperformed. The other people resumed at work the next day and had a conversation with the chairman, but the claimant failed to show up at work. DW1, by denying the claimant's averment, confirmed claimant's averment that other staff who were asked to step aside were recalled while he was denied access to the work premises. The defendant seems to be speaking from both sides of the mouth on what actually transpired or happened after the AGM of 8th December 2016. It is the claimant's evidence that except for the official card that was retrieved, he did not face a panel. He was left in limbo on his status. He was not dismissed or terminated. His identity card and his laptop were not retrieved, but he was logged out of the company software. His email, exhibit C5, C6, and C7, appealing for intervention for his benefits were never responded to. This court is also mindful of the fact that by paragraph 10, 11, and 12 of the statement of defense, the main reason the defendant decided to pay him off was because several opportunities were given to the claimant to show up at work, but were shocked when he never did. There was no exhibit tendered in this regard to show the several opportunities rebuffed by the claimant to report at his duty post. During cross-examination, DW1 was asked, and I quote, you were the acting head of HR. Do you have any document to show you called him or asked him why he did not come to work? DW1's answer was no. And DW1 further confirmed that even after claimant failed to show up at work, no query or termination letter was issued. In Okore versus Una Kalamba, citation provided, the court held that preponderance of evidence is the burden of proof in most civil trials, in which the jury is instructed to find for a party that, on the whole, has the stronger evidence, however slight the age may be. Preponderance of evidence is the greater weight of the evidence, not necessarily established by the greater number of witnesses testifying to a fact, but by evidence that has the most convincing force, superior evidentiary weight, and though not sufficient to free the mind wholly from all reasonable doubt, is still sufficient to incline a fair and impartial mind to one side of the issue rather than the other. It is tried law that all civil cases in Nigeria are decided on the preponderance of evidence or balance of probability. See Yakubu versus Joe Royal, citation provided. This implies that the evidence must be holistically examined and weighed on the imaginary scale to see where it tilts or preponderates. Since parties have joined issues on the fact of being locked out, the evidence of being locked out of the virtual office environment, the virtual work environment, by shutting down the company application software was never controverted. The issue before the court now is to evaluate the evidence adduced by both parties and attached with. From the evaluation of both oral and documentary evidence placed before this court to establish the procedure taken by the defendant, this court is convinced that the claimant's evidence carries more weight than that of the defendant. This court is also convinced that the claimant has been able to prove that he was asked to step aside at the AGM due to underperformance. He was not issued a query, that is, his right of fair hearing was denied. He did not resign. He was not issued with a termination letter. He was never contacted, and he was denied both physical and virtual access to the workplace. The procedure of asking the claimant to step aside at the AGM and later logging him out of the company application software amounted to an outright termination, which was wrongful. From the evidence before this court, the claimant did not resign from his employment. Rather, his employment was terminated by the defendant on the 8th of December 2016. The first arm of the declaration sought by the claimant therefore succeeds in part. On the second arm of the declaration sought that the defendant is in arrears in the payment of the claimant's salaries from December 2016, when he was asked to step aside till today. As earlier stated, the termination of Matthias Abada took effect the day he was asked to step aside. However, the court noted that the payment mode on 2nd of February 2017 is 263,636 naira was payment in lieu of notice. From Exhibit C1, the monthly gross salary at point of entry was 170,000, subject to statutory deductions. Again, during cross-examination, CW1 admitted that it was increased, and in Exhibit C10 indeed indicates that it was increased to 200,000. In Exhibit C10, his bank statement, a perusal from January to December in 2016 indicates thus that on the 29th of July 2016, he was paid 200,000. On the 31st of August 2016, he was paid 200,000. On the 30th of September 2016, he was paid 182,370 naira. On the 1st of November 2016, he was paid 188,800 naira. On the 30th of November 2016, November salary, he was paid 105,473. And in December 2016, there was no payment. On the 3rd of February 2017, 263,636 naira was paid. While there were payments less than 200 in some months, the parties did not tell this court. The defendant in paragraph 16 of his witness statement on oath went ahead to pay 263,663 naira on the 3rd of February 2017, 2 months after her salary in lieu of notice. Apparently, the salary for December was never paid. The Court of Appeal in Ikemba versus Pyramid Company Nigeria Limited held that payment of salary in lieu of notice ought to have been done contemporaneously with the termination of the appellant's employment. The defendant in his final written address cited Bedu versus ETA and Chukuma versus Shell Petroleum Nigeria Limited citations all provided. On the nature and effect of payment of salary in lieu, he submitted that having paid, the defendant dispensed with the need to send a formal notice of termination to the claimant. Learned Defense Counsel did not avert his mind to when salary in lieu of notice is expected to be paid. In Chukuma versus Shell Petroleum Supra, the court held that payment in lieu of notice is at the time of the termination of the contract, which this court has determined was on the 8th of December 2016 at the AGM meeting. It should be stressed that at this juncture, the primary regulation governing employer-employee master-servant relationship is the Labour Act 2004. In section 11 and 20, it entitles the employer to terminate, but the employee must be provided with reasonable notice or payment in lieu of notice, unless in cases of gross misconduct that justify summary dismissal, courts, except in cases of gross misconduct that justify summary dismissal, courts have held that the payment of the salary in lieu of notice should be made immediately at its stage of termination. In Chukuma versus Shell Petroleum, as earlier cited, the court held that when the appellant's appointment was terminated without notice on the 18th of August 1981, that was the date salary in lieu of notice ought to have been paid either directly to him or through his designated bank, and for which he must be informed promptly. Therefore, the payment into the appellant's bank of his salary on the 25th of November 1981 was not in compliance with the contract of service. This court will therefore align itself with the decision of the Supreme Court above and share the view that the fact that Matthias Abada was asked to step aside on Thursday, 8th of December 2016, and he was logged out of the defendant company's software by the 9th of December 2016, he was not contacted and recalled to the workplace by the acting head of HR. The position of the law is that by the conduct of the employer, the employment was terminated on the 8th of December 2016. Therefore, the 1 month salary in lieu of notice ought to have been paid on the 8th of December 2016. In the circumstance, the claimant has established that he did not resign and his employment was not terminated either. In the instant case, can a reasonable man say the payment made about 2 months after the AGM be fully termed salary in lieu of notice? Where the court finds out that the employee's employment was wrongly terminated, he will be entitled to the payment of his salary and other entitlements for the period for which the employee should have been given notice of termination as damages for the breach. See Samson Babatunde versus Afribank Nigeria Limited, citation provided. The law is also on a firm pedestal that the servant would only be paid for the period he served his master. Thus, an employee cannot claim for salaries not earned. See CCB Nigeria Limited versus Wanko Balogun versus Union Bank and Olatubosun versus NISA. Citations all provided. The claimant cannot succeed in respect of heads of claim that imply that the court still regards him as an employee of the defendant. His employment had since been terminated, albeit wrongfully, but not unlawfully, on the 8th of December 2016 at the AGM and cannot be paid for work not done. The second relief one is also seeking for a declaration that the defendant is in arrears in the payment of the claimant's salaries from December 2016 when he was asked to step aside till date. The claimant has been able to establish, and the defendant in his witness statement of oath stated that after about 2 months, the defendant paid salary in lieu of notice. The salary for December was never mentioned. This court is therefore convinced that December salary is still unpaid, and there is no evidence before this court to show how and when December salary was paid. I so find. However, the claim for salary from December 2016 till date fails. I so hold. Relief 2 is seeking for the payment of the sum of 13,200,000 naira as unpaid salary from January 2017 to June 2022, as contained in the employment letter dated 2nd April 2014. From the evidence before this court, the claimant was only entitled to all his salaries and entitlements up to December 2016 when he was terminated, and in addition, a month's salary in lieu of notice. In view of the above reasoning, the claim for payment of the sum of 13,200,000 naira only as unpaid salary from January 2017 to June 2022, as contained in the employment letter dated 2nd April 2014, fails. On the claim for an order directing the defendant to pay to the claimant the sum of 3 million naira, 3,168,000 naira only, which represents in-house weekly allowance in line with the company policy practice and in-house memo dated 9th of December 2014. Exhibit C2 relied upon by the claimant contained no such communication on payment of in-house weekly allowance, but on payment of outstation allowance to staff that are required to work at any given location as determined by the management covering a period above 1 month. The claimant did not lead evidence to show how he arrived at this sum for the in-house weekly allowance. There is no breakdown, neither is there a duration for the payment. The claim is a blanket claim arising from an unknown company policy practice, and the document referred to and relied on by the claimant is a clarification outstation allowance dated 9 December 2014. This court agrees with the argument of the defendant that the claimant failed to adduce evidence as to the specifics of this policy practice. This court is not convinced about claimant's entitlements to this relief, and it therefore fails. The claimant is also seeking for an order to be paid the sum of 2,040,000 naira only, which represents the claimant's annual leave benefit. In proof of this claim, claimant tendered his employment letter, which has in paragraph 4, and I quote, "You are entitled to an annual leave of 14 days and leave allowance of 10% of annual basic pay." He also tendered his statement of account to show he was never paid annual allowance, paid leave allowance. In paragraph 3 of Exhibit C1, it states, monthly gross pay is 170,000 naira. During cross-examination, claimant was asked if there was an increase in his salary, and he answered positive. Exhibit C10, which is the bank statement admitted without any objection, indicates that he was paid 170,000 naira as salary in 2014/2015. In 2016, the defendant company paid his salary amounting to 200,000. In defense to this claim, Learned Defense Counsel argued that the claimant failed to shift the burden of proving non-payment of annual leave benefit to adduce cogent and compelling evidence in support of same. The claim for annual leave benefit is a statutory entitlement. In Nigeria, Section 18 of the Labour Act provides for annual leave entitlement for employees. This court has stated earlier that it would repeat itself again, that the law is on a firm pedestal, that a servant would only be paid for the period he served his master. In Exhibit C1, claimant commenced work in March 2014. He is therefore entitled to annual leave allowance from March 2014 to 2016 only. For 2014, 10% of his monthly pay of 170,000 times 10 months would amount to 170,000 naira. In 2015, based on his monthly pay of 170,000 for times 3 months, it will amount to 51,000 naira. In 2016, based on the monthly pay of 2,000 naira, 200,000 times 9 months, it will amount to 180,000 naira. And in 2016, 10% based on the monthly pay of 200,000 times 12 months would amount to 240,000. The total amounts to 641,000 naira. To the extent that the sum of 641,000 naira is hereby granted to the claimant, the relief succeeds, I so hold. The claimant is seeking for an order of 2,040,000 naira, which represents the 13th month end of year productivity allowance that was never paid from 2014 when he was employed to 2022, as contained in the contract of employment. During trial, the defendant made no effort to discredit the validity and credibility of Exhibit C1, paragraph 4, where this claim is bettered. It reads, and I quote, "You may also be entitled to a yearly 13-month pay. The amount will be 10% of your annual basic salary." Learned Defense Counsel stated that the 13-month salary contained in the letter of employment and some of the benefits contained in the letter of employment and the internal memo were discretionary payments of the defendant. On the use of the word may, Georgeville, JCA in First Bank of Nigeria versus Tade Bimbola, citations provided, stated, and I quote, "I now come to the use of the word may, as used in clause 8 in Exhibit P6. In law, the word may ordinarily is interpreted to mean permissive. Yet, it is now tried law that where the word may is used, a right or obligation is therefore conferred. Then the word may is to be interpreted as shall and is taken as mandatory." Also, the learned jurist Georgeville, JCA in Prince Paul Omonzuawo and another versus Chief Yakubu Ogwadaga and other citation provided reiterated that although the etymological meaning of may is permissive and facultative and seldom can mean must and imperative, it assumes this last mentioned character when there is anything in the provision that makes it the duty on the person on whom the power is conferred to exercise that power. When the exercise of the power is coupled with a duty on the person to whom it is given to exercise it, then it is imperative. See also Adeshola versus Abidoye, Bakari versus Attorney General of the Federation, Adeola versus Ayoba, Adegbenro versus Akintilo, and Adigun versus Osaka, citations all provided, end of quotation. In addition to the above position of the law, this court notes that Exhibit C1, the offer of employment, having been drafted by the defendant company, the court shall invoke the principle of contra pro rentem, which is a Latin phrase and principle used in contract law and document interpretation to ensure that documents are interpreted fairly and that the party who drafted the document does not unfairly benefit from it. In the circumstance, the order for 2,040,000, which represents the 13th month's end of year productivity allowance that was never paid from 2014 to 2016, is hereby granted, to the extent that since the claimant commenced work in March 2014, he is entitled to 13-month allowance from March 2014 to 2016 only. For 2014, 10% of his monthly pay was 170,000 times 10 months, amounts to 170,000 naira. In 2015, based on the monthly pay of 170,000 times 3 months, the amounts to 51,000 naira. In 2016, based on a monthly pay of 200,000 naira times 9 months, the amounts to 180,000 naira. And in 2016, 10% based on monthly pay of 200,000 naira times 12 months amounts to 240,000 naira. The total is 641,000 naira. I so hold. To the extent that the sum of 641,000 naira is hereby granted to the claimant, the relief succeeds. The claimant is also seeking for an order for the sum of 3,542,000 naira, 400 naira only, which represents 18% of the employee's monthly emolument, 10% contributed by the employee for 9 years pension forfeited as contained in the letter of employment. The claimant stated that remittances for the staff contributory pension scheme was never made into his pension account from the date of employment until the last 2 months, that is October and November 2016, before he was asked to step aside. Claimant tendered Exhibit C11, his pension account statement. In his defense, Learned Defense Counsel did not deny collecting same. His argument was that the RSA statement of account exhibited, that is Exhibit C11, was a photocopy. The court noted that during trial, the claimant laid proper foundation for the presentation of Exhibit C11. A perusal of Exhibit C11 shows there was no remittance of pension into the claimant's account for the period of 2014 to 2016. The Pension Act of 2014 was signed into law to address pension. It established a contributory pension scheme with contributions made by both the employer and the employee. The claimant, by his averment, has acknowledged that remittances were made in the 2 months preceding the AGM where he was asked to step aside. This remittance is statutory and mandatory. It is for all corporate entities with more than 5 employees. Claims for the refund is thereby granted for the period covering 2014 to 2016. That is, for March 2014, he is entitled to 306,000 naira. In 2015, based on 18% monthly pay of 170,000 naira times 3 months, is entitled to 91,000 naira. In 2015, 18% monthly pay of 200,000 times 9 months is entitled to 324,000 naira. In 2016, 18 months monthly pay of 200,000 times 12 months is entitled to 432,000 naira. The total is 1,153,800. I so hold. Claimant is seeking for general damages in the sum of 10 million naira only against the defendant for the delay, suffering, and financial hardship visited on the claimant by the defendant for the forced suspension and lack of salary from the defendant from December 2016 till date. Without much ado, I must state that the hallowed principle of stare decisis is not to be soiled by this court, as it is the duty of every lower court to stay bound by the position laid down by a higher court. In this case, the apex court, and much of the mind of the Supreme Court in that general damages should be awarded in cases where termination is wrongful. However, I'm also mindful of the caution that the Supreme Court made in Skybank versus Adegu, where it said that the claimant must prove that he is entitled to the quantum of general damages claimed. There is no doubt that it is a duty of an employee in an action for wrongful termination of appointment to take steps to reduce the amount of suffering that comes from sudden loss of means of livelihood. The law does not expect the wronged employee to stay idle and to depend on the damages claimed. In this case, as stated earlier, the termination carries with it the toga of low performance attached to the claimant. The claimant was able to establish by evidence laid at trial that the chairman CEO asked claimant and other staff to step aside because their performance was low. The issue of performance or underperformance of the claimant was raised during cross-examination. The claimant's case is that he was promoted to group head of audit and later head of inventory and control, and due to his outstanding performance, the defendant company flourished. On how often he ought to issue audit reports in a year, his answer during cross-examination was, and I quote, "You have operation report daily/weekly, which is not time-bound. You have the second report, which is monthly report. We have the third annual report, which is end of the year. A comprehensive reading of the recommendation and the audit reports issued to the chairman CEO in the first 3 months of his employment was a testament that CW1 performed his duties. He earned promotions and commendations from the chairman CEO, and he rendered his reports. During cross-examination, DW1, on the other hand, testified that he had no document to show that the claimant performance was not good enough or low. The express agreement entered into by both parties in an employment contract provides the procedure for determining a contract either by termination or dismissal. As earlier noted, the procedure the chairman CEO took to call out staff he felt were underperforming was unreasonable and wrongful, outside the terms stipulated in the offer letter. Unfortunately, the condition of service or employee handbook was never tendered before this court to ascertain if calling out staff at an AGM who underperformed was provided for as a term in the employment relationship. As far as it is known, AGM is a mandatory annual gathering of a company's shareholders, directors, and other stakeholders. By Section 213 to Section 227 of CAMA 2020, it provides a framework for companies to hold AGM, ensuring transparency, accountability, and good corporate governance practices. A situation where staff are called out and asked to step aside at an AGM in the full glare of staff, management, guests, and probably the media, due to low, poor performance, is to say the least unfortunate. It leaves a sore taste in the mouth reminiscent of an unfair labor practice. I so find and hold. Claimant, even if he wanted to go into private work with anyone, he would be rejected, as he said during trial due to his age. Employers are no longer comfortable with him. The award of general damages to compensate the employee whose character has been tainted and whose ability to work upon wrongful termination has been greatly diminished and cannot be by the rule of thumb, but must be based on sound legal principles. The employee claimant must plead and prove the entitlement to the quantum of the general damages claimed, apart from the failure to pay salary in lieu of notice at the point of termination. The claimant must prove that he suffered damages much more than the ordinary. In this case, the claimant has adequately pleaded and proved that he suffered much more than the ordinary as a result of the wrongful termination by the defendant, who had truncated his career progression due to the wrongful termination. The salary for December was not paid, even in the face of a festive period where family expectation is high. Even in January, no payment was made. Thus, it is clear that the claimant's stay in limbo was a harrowing experience, especially where it is unjustified and could be responsible for depression. Honorable Justice Aruwo-Shegbe in Ezechukwu versus Oha Microfinance Bank, suit number NICN/EN/20/2022 stated that the ILO has equally identified that termination of employment often results in depression and other catastrophic consequences for the dismissed employee, the family, and defendant, as earlier held in the judgment. In the circumstance of this case, by Section 19D of the NICN of NICA 206, in conjunction with Section 254C sub 1 sub F to H of the Constitution of the Federal Republic of Nigeria, the claimant is eminently entitled to the sum of 5 million naira claimed as general damages in favor of the claimant. All the terms of this judgment are to be complied with within 30 days from today, failure of which will attract post-judgment interest of 10% interest per annum on the sums awarded until fully paid or liquidated. I make no orders to costs. Parties are to bear their respective costs. Judgment is entered accordingly. This is the judgment of the court.